Well, welcome. Thank you all so much for joining us here today for our preview of the upcoming Supreme Court term. We're very pleased to have you with us in person, and to everyone joining us online, thank you for watching it as well. It's hard to believe, but it's already time for a new Supreme Court term to begin. We all know the court has decided many important and controversial cases over the past several terms, and it's set to once again hear many important cases involving everything from transgender rights to gun rights to the power of administrative agencies. On top of those cases, there's also a number of potentially blockbuster cases that the court has been asked to take up, but hasn't yet decided whether to do so. Then there's also the controversy surrounding court leaks, court ethics, and the number of cases the court is taking each term, as well as many other issues too. So I'm looking forward to today's conversation with two experienced and excellent Supreme Court advocates, David Thompson and Aaron Hawley. David and Aaron, if you could join me on stage. I'll read a brief bio, and then we will get things started. To my immediate left is David Thompson. He is the managing partner of Cooper & Kirk. David has extensive trial experience in the federal district, circuit courts, as well as at the U.S. Supreme Court. He graduated with both his undergraduate and law degrees from Harvard University and has extensive litigation experience. To David's left is Aaron Hawley. Aaron serves as the Senior Counsel and Vice President of the Center for Life and Regulatory Practice at Alliance Defending Freedom. Before joining ADF, Aaron practiced appellate litigation at several Washington, D.C. law firms. Aaron, too, has litigated extensively in federal courts, including at the U.S. Supreme Court. And before entering practice, Aaron served as a law clerk to Chief Justice John Roberts and to Fourth Circuit Court of Appeals Judge J. Harvey Wilkinson. Aaron received her undergraduate degree from Texas A&M and her law degree from Yale. Please join me in welcoming David and Aaron to our stage today. And we will begin. David will share his thoughts on a few cases, and after that, Aaron will share hers on a few others. So David, I'll turn the podium over to you.
Thank you, Zach, and good afternoon. It's a pleasure to be here at the Heritage Foundation with all of you at the beginning of this new and exciting term. In 1927, the United States Supreme Court decreed that 3 generations of imbeciles is enough. The case was Buck versus Bell, and for generations, law school students have been horrified at the prospect of a single woman being sterilized. But today, we have a brave new world. We have a world in which Democrats and left-wing medical groups, greedy doctors, and transgender activists have all aligned against our children, and they're sterilizing not one child, not thousands of children, but tens of thousands of children across the United States. The gateway drug to sterilization is puberty blockers. The risks are known, and they are many: loss of bone density, loss of mental function, and of course, sterilization. Now, fortunately, there are many states that are fighting back with bans on puberty blockers for children, and I've been honored to work with Aaron and our friends at ADF in defending Alabama, North Carolina, Idaho, and others as they defend these laws. But now the United States Supreme Court will take up the issue and will decide whether there is an equal protection right to have access to these dangerous medicines. It's doing so in a case called Scrimetti, which is named after the fantastic Tennessee Attorney General whose laws are under attack. Now let's start with the facts, and then we'll cover the legal issues. Every child comes into this world with a set of chromosomes. Those chromosomes determine a person's biological sex. The left has invented a new construct, a construct they claim is distinct from sex, gender, and they tout gender-affirming care. But there's nothing affirming about cutting off penises and chopping off breasts. There's nothing affirming about mutilating children, and that is exactly what they are doing. Orwell himself would blush at the idea that this is gender affirming. And there's a big factual dispute that suffuses this case. The transgender activists want you to believe that these drugs are a panacea, that if these children with gender dysphoria take these drugs, they will magically have all of their intellectual and other problems go away, even though we know these drugs stunt their normal developments. In the government's brief, it claims that, quote, all major medical associations agree on transgender medicine. That claim is both false and irrelevant. For decades now, the major American medical associations have been captured by the left. They are nothing more than politicians in white lab coats. Take the American Academy of Child and Adolescent Psychiatry. When it comes to the permanent, lifelong risks of puberty blockers, they believe that children can process and make a wonderful decision about that issue. But when it came to whether juveniles should go to prison for violent crimes, the same organization had this to say to the Supreme Court, quote, adolescents are more likely than adults to engage in risky, impulsive, and sensation-seeking behavior, close quote. The AMA joined, arguing to the Supreme Court that adolescents are, quote, emotionally volatile and susceptible to stress and peer influences, close quote. The American Psychological Association told the Supreme Court, quote, it is clear that juveniles have difficulty with planning ahead, weighing consequences of behavior, and emotional regulation. But now that we're not dealing with prison and the death penalty, these groups have done a pirouette that would make Baryshnikov envious. One is left with the distinct impression that something other than science and medicine is driving the bus here. Indeed, these major medical organizations have opined on public policy statement and issue after issue, from critical race theory to immigration to climate change to affirmative action. And you might be thinking, now, David, these groups would never play politics when it came to LGBT issues. And we don't need to speculate about that, because in the Proposition 8 case, they admitted as much. That was the case, for those of you who are young, that dealt with, in California, a ballot initiative that sought to restore the traditional definition of marriage as the union of a man and a woman. And in that case, one of the issues that we were fighting about is whether LGBT parents and their children had the same outcomes as the children of married biological parents. And on cross-examination, all these left-wing medical organizations had said LGBT parents are just as good as married biological parents. And I asked the leading expert on the other side, I said, let's focus on the T. Let's focus on the transgender. Do you have a single study that in any way addresses this question? No, I don't. Is that statement, therefore, pure politics? Yes, it is. So they've been playing politics with the question of transgender parents and children for a long time. Needless to say, I was quite relieved when Justice Alito and Dobbs said, quote, the position of the American Medical Association does not shed light on the meaning of the Constitution. The leading transgender rights group is called WPATH, and we know that with certainty that politics infected WPATH's much vaunted standard of care for transgender children. It turns out that noted endocrinologist, not Admiral Levine, was pressuring WPATH to come out with standards of care. After Levine applied pressure, the authors of the protocol lamented to one another in internal emails, quote, it is frustrating to have to play politics in our brains as we make these decisions, but it is what it is, close quote. The chair of the drafting committee then complained that trans health is under attack from those applying pressure in healthcare to provide evidence-based care. Imagine having the temerity to want to have evidence-based care for children. Documents reveal that the American Medical Association, in fact, declined to endorse the current version of WPATH's standard of care. And after the AMA refused to endorse these standards of care, the president of WPATH vented to his colleagues that the, quote, current custodians of the AMA are probably some white, cisgender, heterosexual hillbillies from nowhere, close quote. And then he asked them to delete the email, but I guess he doesn't know how email works. In sum, discovery has destroyed the credibility of WPATH as a scientific organization and made clear to the world that it is an organization of radical activists attempting to dress up their ideology in the garb of science. And they're not right on the gender medicine issue, and everybody knows it. There is no puberty blocker medication that has been approved by the FDA for gender dysphoria. They're all intended for cancers and rare hormonal disorders. And interestingly, when it comes to on-label use of these drugs, the FDA cautions about the risk of depression and suicide. But when it comes to the off-label use of these drugs, the FDA doesn't say a word about the risk of depression and suicide. The rest of the world is looking aghast. Research on this issue has become so politicized, and the UK just had a blue panel commission called the Cass Report, and it came out, and the Cass Report concluded that the research in this area is of, quote, a very poor quality. And I do want to apologize to those of you whom I've triggered by referencing events in Europe. I know when Justice Kennedy would do so, we conservatives sort of shook in horror about that. But, I do think that if you look at how these drugs are interacting with European children, it tells you about something about how they will affect American children. And after the UK had this blue panel commission, the Cass Report promptly banned the sale and supply of puberty-suppressing hormones. And Cass wrote, "I can't think of another area of pediatric care where we give young people a potentially irreversible treatment and have no idea what happens to them in adulthood. There are few other areas of healthcare where professionals are so afraid to openly discuss their views," she concluded, recommending extreme caution when it came to these gender medicines. Just this year, Sweden has banned these medicines. The National Academy of France has called for medical practitioners to exercise, quote, "the greatest caution," close quote, with gender medicine. Now, we're not talking about Hungary and Poland. We're talking about England, France, and Sweden, and they understand that what we are doing in this country makes no sense. Perhaps the most important issue and the single most important fact that just explodes the myths of the other side is the fact that children change their mind about being transgender at a very high rate. The latest study shows well over 50% of children 7 years after their first diagnosis with gender dysphoria change their minds and conclude they're no longer gender dysphoric. Who knew that children were impulsive? Now let's turn to the law. The claim before the United States Supreme Court is equal protection, and there are two arguments being advanced by the Solicitor General. The first is arguing that transgender individuals should get heightened scrutiny. Now you might be thinking from law school, don't you need to be a member of a class with an immutable characteristic in order to get heightened scrutiny? And you would be right, that is the rule. And even the Solicitor General can't bring herself to say that transgender status is immutable. And given the study that I just showed it showing half of the children change their minds, it's obvious why she can't say that. So she instead says, well, you don't always have to show immutability. Look at alienage. That's a category where there's heightened scrutiny and there isn't immutability. But even in that context, you need to show political powerlessness. And the test for political powerlessness comes from City of Cleburne, a mid-1980s case, and the test is whether you can attract the attention of lawmakers. Do we think that the LGBT community can attract the attention of lawmakers? When that community says jump, Comrade Kamala and Chuck Schumer say how high. The notion that the transgender community can't attract the attention of lawmakers is ridiculous. And the Solicitor General doesn't even mention the Cleburne case because presumably she knows that she can't meet that test, and so she's invented a new test. Can the transgender community wield political power? Now, there's no support for this new test, but even if there were, the transgender community would certainly meet it, as any Democratic politician will learn if he or she tries to cross that community. So I think it's highly unlikely that the Solicitor General is going to win on that argument. And the next argument that she has is sex discrimination. Now, you might be thinking that's an odd claim because doesn't this law apply equally in exactly the same way to boys and girls? And the answer would be yes. And therefore, it's not sex discrimination. But the Solicitor General will go on to say that if a boy wanted to take these drugs because of early onset puberty, they would be allowed to. And here, the only reason they're not being allowed to is because they are transgender. But that's not true, because if a transgender child had early onset puberty, they could take the drug. And the reason they're not being allowed to take the drug is not because of their status, but because it's not approved by the FDA, and it's not approved by the FDA because it's harmful. So the only hope the SG has is to extend Bostock. Now, regardless of what we all might think about Bostock, I don't think there are 5 votes on the United States Supreme Court to constitutionalize Bostock. Bostock was a statutory case, and I don't know of a single originalist decision in the United States Supreme Court that would follow the Bostock logic of saying, well, nobody at the time of the founding actually thought they were creating this right, but 250 years later, we've discovered this right, and now it's going to be binding on everyone forever. That's not the way constitutional adjudication works, and I don't think there will be a majority of 5 votes to read Bostock into the United States Constitution. So properly understood, this is going to be a rational basis case. And no one disputes there's at least one rational basis, which is protecting children from unproven, harmful medical procedures. The harms are known. They include a lack of bone density, cognitive disimpairment, ovarian problems, metabolic problems, and people who take puberty blockers and then proceed to cross-sex hormones, they will become infertile. And that's important because these puberty blockers are designed to be a gateway drug to cross-sex hormones. Kramer on Seinfeld once said, "Don't fight your body, buddy. That's a fight you can't win." Turns out Kramer knew more about medicine than all these medical groups, WPATH and Admiral Levine combined, because fighting your chromosomes is a bad strategy if you want to avoid sterilization. Now, the other side is going to try to blackmail emotionally the justices by talking about suicide. But the studies all show that there's an increased rate of suicide for transgender children who take these drugs. And don't forget, with respect to rational basis, England, France, and Sweden, unless the court is prepared to say they're all acting irrationally too, we would win. The other side finally comes and says, well, you're trying to force boys and girls to look and live like boys and girls. And there are a few answers to that. One is they can do whatever they want when they're adults. The second is they can dress however they want now. And their real complaint is with chromosomes and biological reality, not with the state. Now, there's one amicus brief that longingly recalls the days of Oriental eunuch priests. I don't think the Supreme Court is going to restore the ancient ideal of the Oriental eunuch priest. But this wolf comes as a wolf, make no mistake. So that's the first case I wanted to discuss. The next one I want to talk about is called Vanderstock. This is a case where, full disclosure, I'm counsel of record in one case. My good friend Chad Flores is counsel of record in the companion case. And this case involves the legality of privately made firearms. And you might be thinking, haven't Americans been making their own firearms for centuries? And the answer is yes, you would be right. But despite the longevity of this practice, the Harris administration, hat tip to J.D. Vance, the Harris administration has now targeted this activity. The Harris administration claims that the recent spike in crime has been caused by privately made firearms. It has nothing to do with Soros prosecutors. It has nothing to do with defunding the police. It's privately made firearms, we are told, by the administration that are causing the uptick. Let me be clear. There's more of an epidemic of pets being eaten in Ohio than there is of violence from privately made firearms. The government's argument starts with a slur. They call the guns ghost guns, but these are just privately made firearms that lack a serial number. And for over 50 years, Republican and Democratic administrations alike have understood that these arms are legal. So what's changed? Has there really been an uptick in violence from these firearms? The short answer is no. Most criminals do not machine their own firearms. They steal them, they buy them in straw purchases, they get them from their buddies, they go to the black market, and all the data shows that's how criminals get their guns. Now, it's true there's been an increase in reporting of privately made firearms. But that's because there was just a new mandate to report privately made firearms. And so one can't infer anything from that. The case, Vanderstock, turns on the meaning of a statute, the 1968 Gun Control Act. And it clearly defines a firearm as, quote, A, any weapon which will or is designed to or may readily be converted to expel a projectile by the action of an explosive, and B, the frame or receiver of any such weapon, close quote. Now note, the concept of ready conversion, it's in A, talking about any weapon. It's not in B, relating to a frame or receiver. And for 50 years, Republicans and Democrats alike acknowledged this distinction. Now, the ATF has tried to bypass Congress and come up with a new rule that says that unfinished frames and receivers and parts that can be converted into a frame or receiver still fall within the statute. But Congress clearly excluded these parts that weren't full frames or receivers. And there are two central flaws with the government's arguments. First, the concept of ready conversion has no bearing on frames and receivers. An item is either a frame or a receiver, it's not. And second, the items in questions are not readily convertible into frames and receiver. The government claims that it's ridiculously easy to take these frames and receivers and turn them into such. We went to a very experienced gun hobbyist. This is a man who makes ammunition every night for fun and has made numerous guns. And we asked him, how easy is it to take one of these unfinished frames or receivers and turn it into a frame or receiver? Notwithstanding all of his equipment and expertise, it took him 3 days. A day to get the parts on the internet, a day to study videos on how to do it, and a day to make the gun. And at the end, he had a gun that was so unreliable he refused to fire it because he was afraid it would explode in his hand. Little wonder that criminals don't want to get their guns through this way. And oh, by the way, it was more expensive than if he had just bought a new gun. Joe Biden wants you to believe that the typical gangbanger can do this within 20 minutes. That's just ridiculous. Rick Vasquez, the former acting chief of ATF's firearm technology branch, has even said that it would be nearly impossible for the average layperson to complete successfully one of these conversion kits. So even from a technical standpoint, the ATF's justification doesn't make any sense. And for anyone who's interested in this, Brad Benbrook did a great amicus brief that shows exactly how difficult it is to convert these parts into an operable firearm. And so it's not surprising that criminals aren't honing their blacksmithing skills. They're out there just stealing or buying them in straw purchases. So I'm confident that the court is going to strike down the ATF rule. The last case I want to talk about is medical marijuana versus Douglas Horn. And if you had told me 5 or 10 years ago that there was going to be a RICO marijuana case in front of the United States Supreme Court, I would have been absolutely delighted to know that our laws in this country were actually going to be enforced. I know we're all aghast at the fact that, Harris has left the border open for the last 4 years and totally flaunted our immigration laws, but, the lawlessness that is at root there really started with Obama and the fact that Obama turned a total blind eye to the fact that anyone who buys or sells marijuana in this country is a felon. And they're a felon today, and they've been a felon for a long time. And so now the United States Supreme Court is going to get a chance to weigh in on this. And Douglas Horn, he bought a health supplement that falsely claimed it had no THC. Then he took a drug test and he failed it. Then he got fired, and then he brought a RICO suit. And his RICO claim is very strong, and I think will be upheld in all respects. The question is whether he has RICO standing, because to bring a RICO claim, you need to have been injured in your business or property. your business or your property. And he's maintaining, well, it's my business. I work. That's how I make a living, and I got fired. And I think there's some force to that as to whether the court is going to agree with that or will think that is too indirect and that's not really what Congress meant when it said business. We will find out. But, certainly the marijuana industry is an industry that is causing huge harm to Americans across the country. And mark my words, their day will come, but it might be in a different term. So now I'm going to turn it over to Erin, and I'm looking forward to what she has to say.
Excellent. Thank you, David.
First of all, thank you so much, Zach. Thank you to the Federalist Society, and thank you for those wonderful remarks, David. And none of us, think that medical associations play politics with children's lives or women's lives, for that matter. One of my favorite examples is Planned Parenthood, an ostensible medical group that, up until a month past Dobbs, stated clearly on its website that treatments for ectopic pregnancies were not an abortion. Lo and behold, that became politically unpopular. And so now Planned Parenthood and the mainstream media is saying, be careful, if you have an ectopic pregnancy, you might not be able to get one, which is absolutely false and again, diametrically opposite what that group had previously said. So thanks for highlighting that, David. Today, I have the opportunity to talk about a couple of cases that are pending before the Supreme Court that they will hear this term. And the one I'm going to start with is Free Speech Coalition versus Paxton. So this case you may have heard of. It is one of the cases raising the age verification component of a law that seeks to protect minors, to protect children from pornography. So as unpleasant as it is, just a few words about sort of the background and the pornography industry in the United States. So statistics show that the average age at which a child is exposed to pornography is about 11. I have an 11-year-old. That is horrifying. In addition, they say that about 72% of children see pornography by the time they're 18. That's the vast majority of children. And we're not just talking about, the district judge in this case had a really interesting view of pornography. He actually said during trial, I've seen movies. They're really as raw as it gets. That is incomplete and wholly inaccurate. If you look at some of these websites that are represented in the Texas lawsuit, they are websites that have 5 or 6 different categories of pornography, everything from animals to teenage, to non-consensual as well as unconsensual, which basically means rape. So we're not talking about movies. We are talking about hardcore porn. We are talking about a billion-dollar industry. We are talking about an industry that uploads continuous streams of content. One of the companies at issue in this lawsuit bragged that if you wanted to view their new material, you would have to start in 1850 and you'd still be going. So a plethora of material, as we know, widely accessible on the internet. So what are states, what are parents supposed to do? So Texas took a shot at this, and they enacted a law that says for these large commercial websites, which are defined as websites containing a third or more of the regulated material, those websites have to age verify before they allow children or before they allow anyone on their website. They have to verify that those entering are not 18 or younger. They're not 18, so 17 and younger. So what Texas does is it says that there are 3 basic ways that companies can do this. Typically, they outsource this to a private company. It happens in other countries as well. And those companies rely on 3 different things, or can rely on 3 different things. One is a government-issued ID. Second, there's a way to look at facial construction and determine if a child is a minor or not. And third, they can look at other characteristics. One of the briefs uses the example that an airline pilot is unlikely to be a minor. So there's these 3 different ways that the Texas law allows for a commercial porn company to verify that a minor is not accessing its website. Enter the big porn industry, sues in Texas, and they allege that the law here at issue violates the First Amendment. And you might be thinking, these are huge industries. These are large commercial porn operators. isn't this commercial speech? But there's sort of an interesting angle here in that the porn operators actually get to raise the free speech rights of their viewers. And this becomes really important because the specific question that the Supreme Court granted cert on is what standard of review applies to Texas's law. And that really, as all of you know, the standard of review is often the whole ballgame. It certainly is likely to be in this case. So a few sort of First Amendment parameters, and then we'll get into the legal arguments in more detail. First of all, as most of you know, obscenity can be outlawed. So obscenity, the Supreme Court has held, sort of know it when you see it. It's a famous line from a Supreme Court opinion. So it's really difficult to know what that category encompasses, but it is unprotected by the First Amendment. On the other hand, sexual content, including ostensibly these porn websites, are protected speech. That's what the Supreme Court has held in a series of cases. So the first question is distinguishing obscenity from sexual content. And a lot of material falls on the sexual content line of things, unfortunately. Then the second thing to sort of realize is since a case called Ginsburg at the Supreme Court, a relatively old case, the Supreme Court precedent has been clear that minors are not entitled to the same First Amendment rights as are adults. So what this means is that states can do more to protect minors from material that is harmful, even under the First Amendment, than it can for adults. So this means, for example, that in the Ginsburg case, the law at issue outlawed retail vendors from selling, quote unquote, girly magazines to anyone under who was a minor, anyone underage. The distributor in that case sued, went all the way up to the Supreme Court, and what the retailer argued in that case was that minors had a right to access this sort of material, that there was a First Amendment right. And the Supreme Court said absolutely not, that the state has more authority, that it can protect minors from harmful material, even if that material would have to be accessible under the First Amendment to an adult. So those are sort of the parameters we're dealing with. And then we get the Texas case, we get Big Porn suing, and what Big Porn says is, well, there's this case Ginsburg, sure, but if you look at a couple of follow-on cases, Reno and Ashcroft, what the court looks to in those cases is whether the law has a substantial effect on speech that will be viewed by adults. So the district court sided with the pornography industry, and it looked at this law and it said it's going to have a substantial effect. It'll have a chilling effect on adults who want to see this sort of information, this sort of material, as is their First Amendment right. And because of that, the law itself is unconstitutional, even though it could be applied to minors constitutionally. The Fifth Circuit took the opposite tack. The Fifth Circuit said, well, if you look at this law, it applies to minors. We know under the Supreme Court's decision in Ginsburg that minors can be protected from harmful conduct. And this is key. Ginsburg applied rational basis review. So the court said it's perfectly rational for Texas to want to protect minors from this material. Texas's law is constitutional. Now, interesting, this is an issue that probably splits some conservatives. Judge Higginbotham dissented. In Judge Higginbotham's view, the cases Reno as well as Ashcroft said that if you do have a substantial amount of material that will be withheld from adults because of a law protecting minors, then it's subject to strict scrutiny. So I wanted to talk just a little bit about the strict scrutiny arguments. Under strict scrutiny, of course, the state has to show a compelling interest. No one disputes that a state has a compelling interest in protecting children from harmful conduct. So the question becomes, can the state show that its interest is narrowly tailored? The porn industry says no, because A, social media companies are exempt, and B, because the parents can simply use filters. Well, Texas has some pretty good responses to both of these. One, Texas says that filters are already ubiquitous, so that's sort of the status quo. That's not something that Texas could do. With respect to the narrow tailoring, that's really, I think, where the rational basis versus the strict scrutiny applies. In rational basis land, then a state doesn't have to address every problem at once. It can move incrementally. It can move step by step. On the other hand, in strict scrutiny land, you do need to show that a statute is narrowly narrowly tailored to address those compelling interests. So I imagine that's something the Supreme Court will focus on. So I think the question is, how do you reconcile Ginsburg with Ashcroft? And what will the Supreme Court use, what test will it use to address that? I don't think it has addressed that specific question before. Oral argument in this case will be very interesting. And I think it's really just the tip of the iceberg as well. As we know from the Supreme Court's decisions in Net Choice and the other cases, how states grapple with social media companies while also protecting First Amendment freedoms is something that's very much will be on the Supreme Court's plate in the next few years. So stay tuned. I'm not sure how this one will come out. The other two cases I wanted to talk about just briefly are one, I love the title, San Francisco versus EPA. Not one that you would expect to see every day. So in this case, San Francisco challenges the decision of EPA to use what are called narrative permitting requirements. They are as amorphous as the term narrative makes them sound. So of course, the EPA is in charge of assuring clean water throughout the United States. And sometimes, rather than defining effluent limits, what it tells a city is, sometimes there are unavoidable situations. If you have a flood like occurred in North Carolina recently, then cities and municipalities are likely to their systems are to be breached. Likely some of that effluent and sewage will end up in waterways. And so the EPA provides a sort of safe harbor for that, so long as they meet these quote-unquote narrative permits. The catch is the EPA never says what those narrative permits require. Instead, they say that you violate the narrative permit if the water quality of the receiving water fails to meet the standards, which has nothing to do with how much the city or municipality has released. So San Francisco waves its hands and says, wait a minute, we've just been sued. We're hundreds of $millions in compliance costs, $1 billion worth of injunctive costs, and we have no idea because the ocean changes all the time, according to factors that we have no influence over. Pretty good argument. Again, San Francisco versus the EPA, but as sort of, politics with medical organizations, politics with the EPA, the state of California has actually come in on the other side. They are against San Francisco and saying EPA is right in this case. However, I think there's a brief filed, an amicus brief by localities around the country, both left and right, saying this is a really big deal. You're going to bankrupt us. So I would imagine, especially post-Loper Bright, that San Francisco will win this one. But again, I'm super excited about the title because I love it when people sue the EPA, especially if their name is San Francisco. The last case here is FDA versus White Lion. Another sort of administrative law case arises out of the Fifth Circuit. The Fifth Circuit took this in bank, and it concerns e-cigarettes or vaping. And the questions are some sort of naughty administrative law ones here. But the oral arguments in the cases were pretty spicy. The Fifth Circuit judges were very upset by what the FDA had done here. In essence, they had worked with this industry, with the vaping industry, who wanted to get approval for flavored vaping things. Not personally in favor with vaping, but what the court said was, you need to have some studies. We're going to look especially at your marketing plans. And why they were going to look especially at the marketing plans was that the FDA wanted to make sure that they weren't tailored to or targeting youth. So they said they were going to look at the marketing plans. So the industry does this. It comes up with marketing plans. It comes up with the studies. It submits them to the FDA. And the FDA says, we're not going to look at your market plans after all, and we're going to deny it en masse. So there's some real questions here about whether the FDA changed its rationale, if this is a post hoc justification under Chenery, and how much leeway the FDA gets. I'm particularly interested in this case because I think there has been, in the Chevron realm, the question is how much deference should an agency get? Typically, you see arguments that agencies like the FDA should get a lot of deference. We even heard David say in his remarks that the FDA hasn't approved puberty blockers, and that's a good reason to think they might be very dangerous. But on the other hand, what sort of leeway do we give to the FDA when it has approved something? How much deference do they get? So I'm curious to see how the Supreme Court wrestles with those sorts of issues. I think Zach had some questions for us more broadly, so we'll turn it over to him.
Thank you so much, Erin. That was excellent. I do have one follow-up for you, David, before we move on to our other topics. You mentioned the Vanderstock case. How does the court's decision last term in the Garland versus Cargill, the bump stock case, how will that impact the court's consideration of the Vanderstock case?
I don't think it's going to play a big role in it. If you look at the briefs, it doesn't play a prominent part. But you're right to raise it because I think it shows that the court is, there are all these overheated rhetorical public policy arguments that particularly those on the left are making. And the court puts that to the side and looks at the words of the statute and says, look, if there's a problem here, Congress can fix it. But we're just going to interpret the statute. I think that's what they're going to do here. And that's why I think we're going to win.
Excellent. Well, earlier this week, the court held its annual long conference, which is the first conference where it reviews petitions after its summer recess. I was hoping we might have some grants or denials from that before today, but we don't. So I'm curious, Aaron, are there any cases currently pending before the court in the long conference that you might be watching?
So one case I think we've been watching is a case that seeks to overrule the Supreme Court's decision in Hill. And Hill is the case that imposes boundaries, buffer zones around abortion clinics. It's been widely known to be a decision that was ripe for reconsideration. And there's a petition pending filed by Beckett as well as Paul Clement. So we'll certainly get some attention. They have denied that issue before, so I'm not sure if they're going to jump into that given the election year. But would be nice if they clarified that issue.
Excellent. How about you, David? Are you watching any?
Well, there's one, I believe the name is Consumer Research, but the issue relates to for-cause removal protection. And basically, as you know, we have this alphabet soup of agencies. And when a new president comes in, oftentimes they cannot impose their will on the agencies. And that's because of a case called Humphrey's Executor from, I believe it was 1935. And in SELA law 4 or 5 years ago, in a case I argued called Collins 3 years ago, the Supreme Court has been chipping away at Humphrey's Executor. And now they're being presented with an opportunity to just put it in the dustbin of history where it belongs. And we will see if they want to do that. There is an alternative rationale of the plaintiff saying, well, just chip away at it a little more. So we'll see if they're in an incremental mood or a mood to really do the right thing and get rid of Humphrey's Executor once and for all. But that would be a big deal if they did that, and it would be very salutary because I don't think the founders envisioned having large parts of the government that they're totally unaccountable to the people.
Yeah, that certainly would be a big ticket case if they decide to take it. I'll stick with you for one more case, David. I know another petition pending is Smith & Wesson versus Estados Unidos, another gun-related case. Can you tell us a little bit about that, or if that's worth watching?
Sure, it is worth watching. Just a little bit of background. There's a law called PLACA that Congress passed in the early part of this century, which was tried to put an end to the lawfare that we were seeing. The left was really coming after the gun industry and bringing suit after suit after suit that was frivolous, trying to hold the gun industry responsible for criminal activity by felons. And the Congress said, look, you cannot be held responsible when there's an intervening causal event, namely someone with criminal intent misusing your product. And that really put an end to it. And then we saw in Sandy Hook, some of the Sandy Hook victims brought a case against, I think it was Smith & Wesson, and were successful there, or excuse me, it was Remington, and had some success in the Connecticut Supreme Court evading that. We're seeing a real uptick in this type of litigation. And now the country of Mexico has come in and is trying to sue the American gun companies for the misdeeds of the cartels, which just seems totally wrong for a number of reasons. And so that's a petition that is pending, and I hope it is granted and that they clarify this area of the law, because the left is, really making a big push at this now again.
Excellent. Well, before we move on to Q&A from our audience members, I want to talk about a couple of larger themes happening at the court today. Aaron, I know one of the criticisms of the court over the past several terms is that it's taken fewer and fewer cases each term. Why do you think the court is taking fewer cases, and what do you think the practical consequences of that have been?
Sure. So there's always, that folks try to figure out why the court is on a downward trajectory, which has really been true for a very long time. One theory is that there were all of these big cases big legislative statutes in the 1970s. We think about the Clean Air Act, we think about the Clean Water Act, and most of those sorts of issues have worked their way through the courts. What we see now are challenges to regulatory actions based on those statutes. So one theory is that there aren't big congressional statutes. I don't find that very persuasive because we have big regulatory agencies doing big things all the time. The court, of course, has a discretionary docket, and I think the court can take more cases if it wants to. It's not choosing to do so. And one effect of this, I think, does play into sort of the legitimacy of the court. We hear a lot about that, especially in the left-leaning media. But the reality is that even with a shrinking docket, more than half of the cases are unanimous. Another 20, 30% are 6-3, one way or the other. The justices scramble in those cases. And so we only have the high-profile cases that the media likes to focus on that have these sort of political divisions that you see most often. Sure. So I think taking more cases would help with that. It would probably also help with fewer concurrences.
It definitely left less reading for all the lawyers involved. I want to talk about the emergency motions docket as well, David, especially as we come into election season. Over the past several election cycles, we've seen a lot of emergency election-related petitions. Of course, some on the left have dubbed this the shadow docket, I think somewhat of a misnomer. What do you think we'll see on that front as we head into the upcoming election?
We did see a lot of that in the year 2020. In part, that was because Democrats were behaving badly, using COVID as an excuse to try to get rid of all sorts of anti-fraud measures. So that may have been a unique confluence of events. The Supreme Court's been clear for 20 years under a case called Purcell that lower courts are not supposed to change the rules of an election on the eve of an election. And so to the extent the United States Supreme Court has an active so-called shadow docket, that is a reflection not of the Supreme Court, but of lower courts misbehaving, ignoring Purcell, and changing the rules at the end of the game. I think some of the lower courts have learned they're not going to get away with that. And so we're seeing, even in our election practice, some more responsible behavior. So I'm cautiously optimistic. We'll see a little bit less of it this time, but it's just inherent. There probably will be some last-minute wrangling up at the court.
One of the interesting developments last term, there seemed to be some level of difference between even the conservative justices on how they used history and tradition in some of their decisions. I know Justice Barrett may have had slightly different views than Justice Thomas or Justice Alito in some cases. How do you think that will play out over this term, Aaron, and maybe in the immediate future as well?
I think that's one of the most interesting theoretical questions confronting the court is how does, starting with Bruin, the court was very clear that when you're talking about a Second Amendment case, then the appropriate test is to look to history and tradition. Since then, there have been various questions that have arisen. Justice Barrett reasonably asked, what time period are you supposed to look at? Is it the founding? Is it the 14th Amendment? How far in time do we go to look at cases, and how are they relevant to that touch point, whether it's the 14th Amendment or the founding? And then I think you do have sort of a burgeoning or maybe even very much a full-throated debate going on between Justice Barrett and some of the other original justices on sort of how important history is. Sure. Justice Barrett, if you'll recall, in the Fulton decision, said that she found the historical question of whether religious observance had been granted exemptions from generally applicable laws to be more silent than supportive. Since then, in a trademark case, she clarified that instead of looking to a particular historical background, she was going to look to the historical purpose. So I think you see sort of some different ideas going on. And another issue, too, is, does it apply outside the Second Amendment context? What about the First Amendment context? Right. And so there's lots of questions.
It will certainly be interesting to watch that play out. One of the other questions I'm curious to hear either of your thoughts on, there's certainly been a lot of leaks coming out of the court recently. Obviously, the Dobbs decision. Earlier this summer, the New York Times ran a rather lengthy piece detailing kind of the inner workings about opinion assignments, some of the justices' private conferences. And so I'm curious, what do you think is driving the leaks, and what, if anything, can the Chief Justice do to combat that?
Well, I think it's a left-wing temper tantrum. They've been used to shortcutting the democratic process and getting their way on a variety of issues, not because they've convinced their fellow citizens of something, but because they convinced 5 people at First Street of something. And now that they can't do that anymore, they're having a temper tantrum, and they're trying to undermine the credibility of the court in various ways. And I think the Chief Justice, I mean, it won't be hard. Strap everyone up to a polygraph machine and say, who did this? And swear under, and criminalize it. Make everyone swear under oath that they were not the leaker, because now they go from having done something that is dishonorable to being criminal if they lie to the federal government under 18 U.S.C. 1001. So that's what I would do. I would make people start swearing under oath that they're not the leaker, and then when we find the leaker, put them in prison.
And I think it's worth emphasizing, too, just how big of a leap this is from traditional Supreme Court practice. The Supreme Court has historically been one that is closed doors, that we don't hear about. Maybe when a justice's papers are published posthumously, then we get some information. But as law clerks, you are absolutely terrified that you might inadvertently let something slip somewhere. And so this is just a huge breach of protocol and integrity, and it's super concerning.
What do you make of the justices, either at different conferences or in different events or talks they've given, airing their views on the Supreme Court Ethics Code that's been proposed, some of the internal court procedures? Do you think that's something we're seeing more frequently now because of some of these leaks and those sorts of things?
Well, certainly the left is trying to undermine the credibility of the court, and so has this drumbeat of ethics complaints. And so I think that is intentional that we see more media attention on it, and so I guess it's not surprising the justices are being asked about it increasingly.
Interesting. Well, I believe we have a few minutes for questions. I know we have a fairly large online audience, some of whom have submitted questions. So why don't we go to an online question first, and then if folks in the room have any questions, please think of those, and we'll come to folks in the room after that. So do we have any online questions that have been teed up in advance? All right, I don't see any. Does anyone in the room have any questions by chance? Sure. And I think we have a microphone, if we can, so that you can hear it.
Mr. Thompson, you made some interesting points about the use of administrative discretion in some of these cases. Now that the Chevron doctrine seems to have its feet cut out from under them, do you think that some of these cases that you've mentioned, particularly that one you mentioned the first time around, are you going to be able to make some significant headway in arguing that Chevron has essentially turned the administrative discretion, weaken it enough so you have a chance to make some good arguments?
Absolutely. I think that was an enormously important decision that we had last year where Chevron was overturned, and now it just takes off the table. The government, in a number of these cases, we would have seen the argument of, you need to defer to our expertise. What we're doing is reasonable enough. Back off. And they can't make that maneuver anymore. And that was always their go-to maneuver in almost all of these cases. And so, yes, in the cases where we were talking about and litigating, certainly the Vanderstock case, Chevron's gone. So we have not had to contend on that. We can really look at, what did Congress intend? What does this statute mean? Let's focus on that, not whether what the agency came up with is theoretically reasonable. So it's very salutary in terms of those who want to rein in the administrative state and the illegality of the administrative state.
I see another question. We have a question here. While we're waiting on the microphone, I have another question. If there is a change in administration, I suspect we may see a change in position in some cases before the court, maybe the Scrimeti case. What would that look out? And practically speaking, how would that play out? Aaron, if it's all right, I'll throw that to you.
Sure. So in Scrimeti, I would expect that the government would drop sort of its infamous briefs where it changes its positions. Sometimes it does that, just in briefing or oral argument. Other times it does this when administrations change in a footnote. Just a footnote says, after further reflection, the Solicitor General or the Department of Justice has changed its views, so we no longer support plaintiffs in this case. In this particular case, there are private plaintiffs represented by the ACLU, so I don't expect the case to go away. The case will probably continue to be litigated, but with the government either staying out of it or switching sides entirely.
Interesting. Sure.
Sticking sort of with Chevron, but bringing up AI, would the court be heading, if they're turning over Chevron, if states now have AI capability, is there a new argument for states' rights for solving things more locally because they have the technology to overcome where a national solution may have been needed due to costs and benefits? So it seems like there's a room for new states' rights arguments if AI capability is there.
Well, I think AI capability is something that is going to become more relevant to some of these types of questions. I can tell you, if you lived in New York City and you wanted to buy a gun, you would have to pay close to $500. And the city of New York says because that's what it costs our bureaucrats to process your application. Now, I have a feeling that ChatGPT could do that a little cheaper than $500, and it could do it a lot faster than the bureaucrats in the city of New York. So I do think it will be an extra argument that a lot of us can make of saying, like, look, what you're doing makes no sense. You need to streamline things. You need to stop harassing citizens with bureaucratic red tape, which could easily be avoided with AI.
Excellent. I think I saw John, and then one more in the back.
We talked a lot about Loper Bright and Relentless and how this is, Brand X is now gone. I assume our deference is going to fall. The next big thing out there, it seems to me, is the non-delegation doctrine. Supreme Court's given some teeth when private entities are involved in those delegations and have an interest, the little teeth of the private non-delegation doctrine. But they haven't really touched yet on delegations to executive branch agencies, and I'm curious whether you see a good vehicle to do that and whether you sense that there's appetite among the justices to give some teeth to the non-delegation doctrine.
So I certainly think the non-delegation concerns were driving a lot of the resistance to Chevron, sort of the flip side of the same coin. A few years ago, the court had a case concerning SORNA, the Sex Offenders Registration Act, and in that statute was kind of an incredible statute. What Congress said is it set out a program of registration for sex offenders that it offended after the enactment of the statute. But for sex offenders who had been convicted before the act was enacted, what Congress said was the Attorney General can figure out how to deal with them. Which, as someone arguing it said, that's like half of a statute. And the court refused to find that violated the non-delegation doctrine. Justice Alito had a concurrence in which he said if the court was going to reconsider it, he'd join them, but they didn't have the votes in this case. So there certainly are a number of justices interested, Justice Gorsuch, Justice Alito. My guess is that they'll maybe see how Chevron shakes out first, but.
I think that's a good prediction, yeah, and I don't know of a case this term that presents that, but yes, it's one we're all waiting for.
Well, I think we have time for one final question. I see one in the middle of the room there.
Thank you all for talking about what's coming up. And I'd like to ask about another case that wasn't addressed, Williams v. Washington. And for those who are into federal courts issues, it's a niche issue of whether you have to exhaust administrative remedies for a Section 1983 claim in state court, obviously raising a lot of questions about when federal law can trump state procedures and other things like that. Do you have any sense of where the court might be going on a case like that or other similar cases that there are pending in the cert petition watch?
Well, I know, for those of us who do takings work, we struggled with Williamson County from, about 1985 to 2019 or so when the Nick case came out. And for those of you who aren't, enmeshed in this, basically for a long time, if somebody took your property, if a state took your property, you could not sue in federal court if the state had a reasonable, certain, and adequate procedure for trying to get your money or your property back. And the Supreme Court in the Nick case in 2019 or so said, no, that we're abandoning that. We're reversing that decision. You don't have to go through that. So I'm cautiously optimistic that they will expand and continue to take away those sorts of procedural barriers to vindicating constitutional rights. But I don't know the details of that particular case.
I don't know the details either, but I second what David said, and it was even worse in that a case called San Remo said, once you've gone to the state court and state administrative proceeding, then it's res judicata, so you never get to raise it in federal court. And if those are the facts in this case, then I think that would be a good reason for the court to find that state administrative remedies aren't required.
And there's very interesting, I know, amicus brief that's been filed by the state of Tennessee. Many other states have joined as well in that case, basically asking the court to consider whether and to what extent Congress can compel state courts to hear certain federal claims. So always an interesting issue. Well, unfortunately, we are out of time today. Thank you all so much for joining us for Heritage's 2024 preview. Please join me in thanking Aaron and David for being with us today as well. Thank you all. Thank you.